Good afternoon. Welcome to the Supreme Court of Florida. Our 10th and final case on the docket today is CBA versus State of Florida. Counsel, when you're ready, you may proceed.
Chief Justice Rowe, Honorable Justices, and may it please the Court. My name is Sophia Masnikoff, and along with my co-counsel, Olivia Robbins, today we represent the petitioner in this case, CBA. Of the two issues before the Court, I'll be presenting the first issue, that the application of Florida Statute Section 836.15 violated petitioner's constitutional rights to free speech. Would the Court like a brief summary of the facts?
I think we're familiar with the facts.
There are two reasons this Court should reverse the judgment of the 7th District Court of Appeal. First, the Florida Statute Section 836.15 does not survive strict scrutiny. And second, the statute is unconstitutional as applied. The statute is a content-based speech restriction and therefore must survive strict scrutiny in order to be constitutional based on Miles v. City of Edgewater Police Department, which states, content-based speech restrictions will not survive strict scrutiny unless the government can show that the regulation promotes a compelling government interest and that it uses the least restrictive means to do so. However, the statute in this case is not narrowly tailored to promote
What makes it content based?
Because in this case the statute is focused on limiting the speech itself, the message of the bullying, it's not focused on the reaction to the bullying, therefore it's content-based in this case. So this statute is not narrowly tailored to either government interest. First, the government interest of punishing students for using their cell phones as disruptions in schools, and second, the government interest of protecting individuals from cyberbullying. And first, the statute makes no mention of either schools or phones, so therefore it's not narrowly tailored to that government interest. And further, petitioner's post was not narrowly tailored and was not directed towards any one individual and was made as a general statement about the totality of the school and the basketball team as a whole. Further, in Tinker v. Des Moines, the court held that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The court held that fear of disturbance is not enough to limit the right to free speech. In this case, although there was some disturbance with students leaving their classes, it's not a substantial enough disturbance for the government to limit the fundamental right of free speech in this case. Just because it may be a distraction in the classroom, it's not enough.
Counsel, on that, I'm sorry, go ahead. Isn't a group of students storming out of a class, isn't that distracting? Isn't that disruptive to the teaching environment?
Yes, Your Honor. However, in this case, that disruption did not affect the entire school, and therefore it's not substantial enough for the school to regulate their speech and for the government to regulate their speech.
So disruption in 1 or 2 or 3 or 4 classes isn't enough. It needs to be the whole school before the statute can kick in.
Yes, Your Honor. However, in Mahanoy area, school district VBL, that disruption was limited to like 5 to 10 minutes and over multiple days, and I still said that that was not enough for the government to limit their speech. So in this case today, their government interest was only 1 day, and it was only a couple of students leaving class, and therefore it's not enough for them to limit their speech. Further, the statute is unconstitutional as applied. In State v. Conforti, the court said that they will strike down a content-based regulation as unconstitutional unless the government can show that the message being suppressed poses a clear and present danger. However, in this case, although there was some disturbance, there was no threats or acts of violence that could constitute a clear and present danger. Therefore, the school officials did not have a right to regulate their free speech based on a clear and present danger test.
So you're saying that if the statute is fine if it involves a threat or intimidation or physical violence-oriented things, but the statute has problems if it involves lesser things, maybe like the teasing or the humiliation?
Yes, Your Honor. This statute is also too overbroad. That, like teasing and social exclusion, the statute prohibits speech that may be legal and constitutional, and therefore it sets a dangerous precedent that any speech could be deemed unconstitutional and could be limited.
How is it overbroad when it is limited by speech that inflicts physical or psychological distress on one or more students?
Yes, Your Honor. The statute does not specify that this is for in schools only, or even that it's through the use of phones, which was the compelling government interest in this case. And so it's not narrowly tailored, and it's too overbroad because it criminalizes a lot of speech, not just cyberbullying. It prohibits teasing and other speech. Like, even if I were to say a positive message, that it could be seen as, if someone were to receive it negatively, that would constitute under the statute and be criminalized.
Does the intent of the person making the statement, is that relevant, or is it in the perception of the victim of the speech? Is that the relevant inquiry? What focus should we have?
Well, in this case, the statute did not specify intent. However, that's another reason why it's too overbroad, because it's really unknown what intent that CBA had. CBA may not have had the intent to public humiliate the basketball team in this case, but she was still criminalized under the statute. And further, in Mahanoy, the court outlined 3 categories of speech that schools can regulate. And although petitioner's Instagram post occurred on school grounds, it did not fall under any of these categories. And CBA was only expressing her opinion. And based on Tinker, schools should be a free marketplace of ideas where students should be able to express their opinions, and this statute directly limits this. Chief Justice Rowe, I see that my time has elapsed. May I briefly conclude?
You may.
We rest on our written brief for the remainder of our argument, and for the aforementioned reasons, this court should reverse the judgment of the lower court and find that Florida Statute Section 836.15 is unconstitutional and violates petitioner's rights to free speech. Thank you.
Thank you, counsel.